Hello, my name is Lee Chitwood. I'm the Juvenile and Domestic Relations District Court Judge for Pulaski County. The Pulaski County Domestic Violence Committee developed this video to help you understand and follow the terms of your protective order, and ultimately to keep our community a safer place to live. This video explains family abuse protective orders, what happens if a protective order is violated, and how to change or end an existing protective order.
Please keep the following in mind as you watch this video.
This video is for informational purposes only and should not be considered legal advice. You should consult an attorney if you have any legal questions. The video is limited to family abuse protective orders.
Please remember that this video was completed as of July 1st, 2020, and state and federal law change rapidly.
To get started, here are some quick definitions.
A protective order is an order issued by a court or magistrate to protect an individual, his or her children, and other family or household members of the petitioner by setting specific conditions and limitations for an abuser. The petitioner is the person seeking a protective order. The respondent is the person subject to the protective order. Family abuse is any act involving violence, force, or threat that results in bodily injury or places one in reasonable apprehension of death, sexual assault, or bodily injury. Such act specifically includes stalking or forceful detention.
There are 3 types of family abuse protective orders: emergency protective orders, EPOs, preliminary protective orders, PPOs, and permanent protective orders, POs. Emergency protective orders. Magistrates primarily issue emergency protective orders, and they may do so at the request of the petitioner or law enforcement, with or without a criminal charge. An emergency protective order may require the following: no acts of family abuse or criminal offenses that result in injury to person or property. No contact with the petitioner or the petitioner's family or household members, including prohibiting the respondent from being in the physical presence of the petitioner or family or household member. Physical presence includes 1. Intentionally maintaining direct visual contact with the petitioner, or 2. Unreasonably being within 100 feet from the petitioner's residence or place of employment. Exclusive possession of the residence the parties occupied. Possession of a companion animal. Important note: an emergency protective order normally expires at 11:59 p.m. on the 3rd day following its issuance, but you should obey the date and time your order expires.
Preliminary protective orders. Unlike an emergency protective order, a judge must issue a preliminary protective order, and this is usually done following a hearing at which only the petitioner is present. If the judge finds that family abuse has occurred, he may order the following: the respondent shall commit no acts of family abuse or criminal offenses that result in injury to person or property. The respondent shall have no contact with the petitioner or family or household members of the petitioner. The petitioner shall have exclusive possession of the residence the parties occupied. The respondent shall not terminate or shall restore utilities for the residence, such as water, electricity, telephone, and gas. The petitioner shall have temporary possession of a motor vehicle owned solely by the petitioner or owned by both the petitioner and the respondent. The respondent shall provide suitable alternative housing for the petitioner and the petitioner's family or household members, including paying a deposit to connect or restore necessary utilities to this housing. The petitioner shall have possession of a companion animal. Such other relief as the court finds necessary to protect the petitioner or the petitioner's family or household members. Important dates on the preliminary protective order. A preliminary protective order normally expires in 15 days, but you should obey the date and time your preliminary protective order expires. The preliminary protective order will state the date and time of the next hearing. At that hearing, the court will decide whether to issue a full protective order.
Permanent protective orders. Protective orders are issued after a full hearing before the court. Both parties have the right to be present and have the right to testify and call witnesses in their behalf. Both parties may hire an attorney to represent them. If a judge finds that family abuse has occurred, he may order the following. The respondent shall commit no acts of family abuse or criminal offenses that result in injury to person or property. The respondent shall have no contact with the petitioner or family or household members of the petitioner. The petitioner shall have exclusive possession of the residence occupied by the parties. The respondent shall not terminate or shall restore utilities for the residence, such as water, electricity, telephone, and gas. The petitioner shall have temporary possession of a motor vehicle owned solely by the petitioner or owned by both parties, and the respondent shall not terminate the insurance, taxes, and registration of such motor vehicle, or shall maintain the insurance, taxes, or registration of such motor vehicle. The respondent shall provide suitable alternative housing for the petitioner and the family or household members of the petitioner, including paying a deposit to connect or restore utilities to this housing. The respondent shall participate in treatment, counseling, or other programs the court deems appropriate. The petitioner shall have possession of a companion animal. Any other relief the court finds necessary to protect the petitioner or the family or household members of the petitioner, including temporary custody, visitation, or support of a child. Important date on the protective order. A protective order may last for as long as 2 years, but you should obey the date and time your order expires.
Frequently asked questions.
I just got served with a protective order. Now what?
First, you should read the protective order in full, including the firearms warnings. If you do not understand the order, consult a lawyer.
Can I appeal the protective order?
You can appeal the final protective order, but you should keep the following in mind. You must appeal the protective order within 10 days of its entry at the permanent protective order hearing. If you wait too long to appeal, the circuit court may not hear your appeal. If you appeal, the protective order stays in place until the circuit court changes or ends it. Remember, only a judge can change a protective order. You must appeal the protective order in the clerk's office of the court that entered the protective order.
Concealed weapons permits. Under Virginia law, you cannot have a concealed weapons permit while you're subject to a protective order. If you have a concealed weapons permit, you must surrender it to the court that issued the protective order. The circuit court that issued your permit will also enter a separate order revoking the permit.
Firearms.
Effective July 1st, 2020, you cannot transport, purchase, or possess a firearm while you're subject to a final protective order. For the first 24 hours after the protective order is served on you, however, you may possess and transport a firearm in order to surrender it to law enforcement or sell or transfer it to a dealer or person who can lawfully possess a firearm. You must complete the firearm certification and return it to the court that issued the protective order within 48 hours of the time the protective order was served on you. If you fail to turn this certification in on time, you may receive up to 10 days in jail and a $250 fine. Finally, under federal law, you cannot possess a firearm or ammunition while subject to a protective order.
No contact. What does that mean?
It means just what it says. A respondent shall have no contact with the petitioner. It includes, but is not limited to, face-to-face contact, phone calls, text messages, emails, cards, gifts, flowers, gestures, messages that are sent through third parties, and messages through social media. If in doubt, don't do it. If you see the petitioner, go the other way.
What could happen if I violate the protective order?
If you violate a protective order, any of the following may happen. You could be charged with contempt of court and receive 10 days in jail. You could be charged with violation of a protective order and receive up to 12 months in jail and $2,500 fine. If you are convicted of violating a protective order, The court must give you at least 24 hours in jail. If you are convicted, the court must issue a new protective order that could last an additional 2 years. If you are convicted, you will be required to give a DNA sample.
Can the petitioner violate a protective order?
The protective order only requires the respondent to do certain things, and the petitioner therefore cannot violate the protective order. The petitioner should not, however, contact the respondent while the protective order is in place. The petitioner may undermine the enforcement of the protective order by contacting the respondent.
The petitioner keeps contacting me. What should I do?
Do not respond. The order stays in place until a court ends it.
Can the court end or modify a protective order before it expires?
Only a court can end or modify a protective order. The parties cannot change the protective order, even if they are in agreement. Either party may file a motion with the court asking to end or change the protective order. This motion must be personally served on the other party, and the court will require a full hearing on the motion. If the court believes the protective order should stay in place, it can deny the motion to end or change the protective order. The court can also keep the protective order in place but allow contact.
Does ending the protective order change my bond?
No, the protective order and the bond in your criminal case are entirely separate, and changing one does not affect the other.
What about my things?
With the exception of certain motor vehicles and companion animals, the juvenile court does not have jurisdiction to divide personal property and cannot help you retrieve your personal property.
I was told the protective order will be entered in VSIN. What does that mean?
VSIN is the Virginia Criminal Information Network. The clerk, along with law enforcement personnel, will enter the respondent's identifying information and the details of the protective order into VSIN. This information is then available to all law enforcement agencies nationwide.
A final word to petitioners.
Please remember that protective orders are designed to keep you and your family safe. The following will help ensure that safety. Keep a copy of the protective order with you at all times. Do not contact the respondent. This may undermine enforcement of your order. And keep in mind, only a court can change or end the protective order. Thank you for watching this video. I hope it has been helpful. With the cooperation and understanding of all parties, we can maintain a safe and peaceful community.